Friends, we are going to start now. This is today's 163 Friday group meeting. The speaker is our beloved young advocate, promising advocate, Mr. Devashish Bharuka. The topic is Employees Pension Amendment Scheme 2014, Impact of Supreme Court Judgment in Employees Provident Fund Organization versus SUNIL Kumar. It was reported in 2022, SEC online, Supreme Court 1521. This is a recent judgment. Please, I request Rahul Agarwal say few words about Bharuka, his CV.
Sir is practicing advocate in New Delhi. Sir requires his law degree from the Bangalore University Law College in year 2000, or after which did LLM from the prestigious Harvard University, USA. Okay. He became an advocate on record in the Supreme Court in December 2006. Sir has been joint treasurer of the Supreme Court Bar Association in 2015, and he is presently working on a book related to the governments in India. He is also pursuing PhD at Jindal Global Law School. His research is focused on judicial delays and how it is shaping the judicial review jurisprudence of India.
We'll go small introduction. We'll go one by one.
Yes,
G.Seshagiri, myself. Yeah, tell me your name.
Naveen. SUNIL Kumar Mishra.
Name, your name is
Parashuram Mandal. Parashuram Mandal.
G.D. Burman.
Anshuman sir.
Kumar.
Rahul Agarwal.
Nitin Kumar. Rajesh Kumar. Amit Kumar. Keshav.
Giriraj Singh Rawat.
Yeah, I think should be fine.
Yeah. Now you can please select.
Yeah. Okay. Good afternoon, friends. Firstly, thank you so much for inviting me to this August gathering. It's always a pleasure to interact with brothers and sisters. The topic today is about the employment pension scheme, and specifically the judgment of the Supreme Court, the recent judgment of the Supreme Court in the EPFO versus the Sunil Kumar B. Now, this is a 3 judges judgment. The judges we had was Justice Uday Lalit, as he then was, and Justice Anirudh Bose and Justice Dhulia. The judgment has been authored by Justice Bose. Now, before I go on to the judgment, as you all know, just a bit of statutory background to this entire matter. As you all know, 1952 is when we had the Employees Provident Fund Act, which was enacted by the Parliament. The whole idea was to have a social security legislation primarily for the employees. In 65, Justice Gajendra Gatkar, in a judgment, he indicated that this is a beneficial legislation. It is for the benefit of the employees. The idea was that the employees who after at the end of their entire tenure, after their retirement, they would not have anything left in hand. The idea was that there will be certain contribution made from their pay, from their salary, into a certain fund known as the Employees Provident Fund, so that can at the end of their career could be handed over. Now, it so happened that over the years, one realized that just this fund would not really help. What is also required is some kind of a pension. So initially the concept of family pension came about sometime in 70s. There was an amendment in the Act inserting section 6 capital A, which provided for family pension. So family pension was basically about in case the employee during his tenure, the employment tenure would expire, so certain family pension would go to the members. So that was the concept really in terms of how the family pension moved on. But again, the experience showed that that would not itself be helpful. So then is where 6 capital A was substituted by the Parliament to bring it in its present form, the pension scheme, the employees' pension scheme. Now the idea was, when the Lok Sabha was debating this particular amendment, the discussion came about as to the problems which are facing with the family pension. And they realized that number one, that there is no real pension in the hands of the employee once he retires. That is what is required, one. Number two, there was nothing like a disablement pension. So that's another problem people were facing. And at the end of it, even when the employee after retirement dies, there was no family pension available. So keeping in mind that particular requirement, Section 6 capital A was substituted in the present form so that we have a family pension scheme. And the first family pension scheme came about in 1995. So that provided about that what is the requirements, what all has to be done. So the idea was this: they did not want to burden the employees further. So whatever contribution was being made by the employees to their provident fund and the employers, it is from that itself that the employment pension scheme would be generated. Of course, the original family pension scheme fund was also there, so that was incorporated as the employees EPS scheme, and from the employees contribution itself there will be certain amount which will be transferred over to the employee pension scheme. So there was no additional burden. Central government again was required to put in some extra amount, in terms of 1.19% into the scheme. So that was really the structuring of how the scheme came about. This was 1995, and in terms of in case of death of the employee, then the pension scheme would shift over to the family. The family would get the benefit. Otherwise, whenever he retires, at that point of time, that monthly pension scheme continued. Now there was this option. There was the ceiling limit earlier in terms of 6,500, which was enhanced ultimately to 15,000. So ceiling limit to which there will be a contribution made. But in case the salary is beyond the ceiling limit, then there was an option provided in the scheme itself where the employee can opt for having a higher contribution made in terms of percentage from the higher salary beyond what the ceiling limit is. So that was the option which created a lot of trouble. The option provided that option has to be exercised within a certain period of time, which was 6 months. A lot of people had not done so. So the issue came about as to whether they can go for that option. The matter came up to the Supreme Court in R.C. Gupta, and that's where the Supreme Court held that that option really cannot be restricted in terms of a cut-off date. Being a beneficial legislation, it can be exercised even after that. So that was sometime pre-2014 amendment which we are really concerned with. So that point of time, R.C. Gupta held that can be done. It is at that point that 2014 amendment came about, which today we are concerned with. The 2014 amendment, there were certain areas which they built up. First of all was in terms of enhancing the 15,000 amendment. There was another option provided. So now this amendment provided that in case somebody wants to continue with the system, they have to give another option that was under paragraph 11.4, where you give a joint option along with the employer, and there if required for instead of that 15,000 is what the enhanced limit was. So in case you want to go beyond 15,000, in that situation that option has to be given. What was important was one more addition was given by the scheme which the Act never provided. That was the additional contribution of the employee at 1.16% beyond what was been given in the Provident Fund. This is something which was new, which was put in over there and probably troubled the employees, because originally when 6 capital A was inserted, specifically there was a suggestion made for amending saying that employees' contribution should be enhanced, and that was specifically rejected by the Lok Sabha, saying no, that's something we do not want to additionally burden the employees. It should come up from the present contribution of the employer. It should come up from the present family pension fund which is there. But we should not be looking in terms of burdening the employees further only because we want to offer pension to them at some point of time. It was this provision which is now inserted in the scheme beyond what was provided in the Act by saying employees should also insert. So that was the first proviso to 11.4 in the new amendment of 2014. The second proviso again provided for a time limit, that within a certain time limit you should have this joint option. Otherwise, you would not be able to take the benefit. Now, this particular amendment as a whole was challenged before Kerala High Court, it was challenged before Rajasthan and before Delhi High Court. Now, all these 3 High Courts, for different reasons, they struck down this amendment. There was an issue of exempted establishment as well before Delhi High Court, that I'll come to a bit later. So that is how all these matters came up before the Supreme Court in this present judgment we are discussing. There were also around more than 50 writ petitions which were filed before the Supreme Court, challenging this issue, the entire approach of the authorities. So the authorities' approach was this: they took cut-off dates strictly. You see, if you come before cutoff date and you seek for those enhanced options, we will not be able to help you. So even though R.C. Gupta at some point of time had said that the cutoff date is something which for the beneficial legislation should not be taken, but even under the new amendment, what the courts, what the authorities took the stand was that beyond the cutoff date, we will not be able to accept this option where you can contribute more towards your higher salary. So that is how the entire matter came up before the Supreme Court. Now the Supreme Court had this multiple issues, and I'll go just one by one in these issues. Number one was the issue about the validity of the 2014 amendment itself, the modification of the scheme, and whether the authorities, the government had the power to modify the scheme. That was specifically held that it is valid and they have the power, particularly section 7 of the act provided for them to permit, along with the third schedule entry 10, where they can alter the scheme in terms of the pension permissible, etc. So that is the first finding of the Supreme Court, the first take we get. And I think the discussion on this wasn't too much. It was, I think the argument was went over quite a while, but at the end of it, the discussion in the judgment is quite limited in the sense they've referred to these provisions and they've said that no, this is clearly a valid provision, so there is nothing wrong in terms of modification. The second issue was about the R.C. Gupta applicability and whether R.C. Gupta itself is correct or not, because the authorities were very clear that when there is a clear cutoff provided in the pension, that within 6 months you are supposed to take the option, otherwise you cannot proceed. Number one, they said the R.C. Gupta reasoning is perfectly valid. There is nothing wrong in the R.C. Gupta reasoning. It is a beneficial legislation and therefore we cannot deprive the benefit of this legislation or the scheme on the basis of these cutoff dates. That's something which is permissible. However, in terms of applicability of R.C. Gupta, in this particular judgment, in this particular 2014 amendment, they held that this is not applicable because R.C. Gupta has been given in line with the pre-amendment situation. So therefore, at least applicability, R.C. Gupta would not really apply stricto sensu, but then they uphold the principle over there in terms of R.C. Gupta. The third issue was about the methodology. So there was an amendment also in paragraph 11 that instead of the last 12 months salary, the last 60 months salary would be adopted. So that was another question which came before the court. Again, I think in a very short paragraph, they looked into the provisions and they said that it is a reasonable, quite a reasonable methodology. There is nothing wrong in that system, and therefore we accept that methodology what has been adopted by way of this 2014 amendment. So again, that is something they kind of just touched and they went ahead. Much argument was done in terms of what is the financial impact. So the Kerala High Court had noted that they have a huge corpus at this point of time in the coffers of this employment and this EPF fund and the pension, and therefore there wasn't really a requirement of this kind of amendments to be done. The authorities had come up with some other reports, actual reports indicating that we are actually into negative, and today if you are unable to collect this additional contribution, we will be in a deep financial trouble. They try to distinguish between the provident fund versus the pension fund, and how the pension fund is an ongoing liability, and therefore it is important that the fund should be safeguarded in terms of the contributions of the employees and the employer. So there was a lot of arguments, quite a bit of, I remember the huge reports and financial reports being submitted. But again, I think the judges were very clear in terms of what they would want to do. So they were careful. Again, in a very short paragraph, they looked into it and they said that this is something which is really a policy issue for the government. So we were not lying to look into those details and whether this is required, not required. They are the best persons to look into it. So as a policy issue, it is always better that the government, that the court should be away from this particular decision. And they did not really bother. They prima facie, they felt that the funds would be required, and how it will be utilized, how it will be ultimately invested or disposed of, that is all the policy decisions of the government. So that was really about the financial impact. Now we come in a very major issue is about the classification on the basis of salary. So he says that whether there can be classification, whether there can be two kinds of employees which can be created. One which is up till 15,000 rupees and other which is the up to 15,000 plus. And whether those two classification can be done for the purposes of employees. So again, the court, after looking into the material, they felt that this is a reasonable classification. There is no harm. And why it said so was, the reason it says that an option has been given to those whose salary are beyond 15,000. So once an option is given, it says that is something which is reasonable in case somebody wants to contribute more because their salary is beyond 15,000. that is something which can be done, and therefore there is no discrimination as such between the two categories of employees. That is something which should be permissible. So that was the Article 14 application. Now we come to the issue of the option, which was really the bone of contention. Now paragraph 26, subpara 6 of the Employees Provident Fund provides that in case somebody wants to contribute on the basis of their higher salary, they can give an option. So all the people who were here, they had given their options for that higher salary under paragraph 26(6) of the Employees Provident Fund scheme, the EPF scheme. The pension scheme is separate. The EPF scheme, they had given that kind of an option for the higher salary. So then the issue was, what happens to those employees who have given a higher salary? Is it that automatically then they are also entitled without giving the option? They are entitled straight away for a higher salary option even under the EPF scheme. So the court said that though they had given an option there, they do automatically come and a part in the pension scheme, but they are still supposed to give another option. It is not that automatically you will fall under the option scheme over here. If you want to have that higher salary option even in the EPS, you must give another option of yours, because that was only for the purposes of the Employees Provident Fund scheme. So far as the pension scheme is concerned, a different and a separate option has to be given. So though they said you do fall automatically, you become members over here of the pension scheme, but the next level of having a contribution on a higher pension, on a higher salary, you must give another option. So that option was under the unamended paragraph 11(3) of the original 95 scheme. That's the first option you should have given. Then the issue came about, if that is the first option, then 2014 amendment, para 11(4), the second option. Then the issue came about in terms of these two options, because that is where the fight really was. The fight was after 2014 amendment, 11(4) option was to be given. Now quite a few were unable to give the original 11(3) option because of the cutoff date which the authorities were pushing forth. So the original problem of the first option not being able to give because of authorities felt there is a cutoff date of 6 months and therefore will not accept, that followed up along with the amendment in 11(4) again. Because 11(4) says if you already have given the option, you have now the option of giving the second one. The authorities said you haven't given the first option, there is no question of a second option now. So that was the problem which now the Supreme Court had to face. That what happens first to the first option and then the second. But because of the R.C. Gupta dictum, R.C. Gupta having held that the cutoff date would not apply and he could have given an option because of beneficial legislation, and the confusion which got created because of the stand taken by authorities, and finally what R.C. Gupta holds, the court was faced with a situation, what do we do now? There is this first option, time is gone, nobody has done it. Second option is something which you would like to give, but they are unable to give because they have not given the first option. In this situation, first of all, the court looked into 4 categories of employees, which the Kerala High Court had originally noted in its judgment. The first category was those who had retired prior to the prior to the 1995 scheme. So number 1, they have retired prior to the 14 amendment. So number 1, they had taken the option but retired. Number 2, they had not taken the option and retired. Number 3, post 1914, those who are still serving and they have taken the option. And 4, post 1914 who are serving and who have taken the option. The 4 categories is what the Supreme Court now looks into depending upon the option situation. Before handling into the specific directions, what the court does in terms of options, even though you have not taken the first option because of all the confusion being created, and now you are unable to take the second option, court merges the two and says, I'll permit dual option. So that you merge the first option which you are unable to take because of the confusion, you come with the second option. So the dual option is what the court now permits, saying that employees can now, so this is where the crux is coming, the employees are now permitted to take straight away a dual option, both of them together into a single, so that they don't miss out on the original option of a higher salary, contribution on a higher salary. So today the court has permitted that an employee can take a dual option within a period of 4 months from the date of the judgment, employer and employee together, can give the option so that the benefits of the higher salary contribution can be enjoyed by the employee. So that's the first thing which has come up in terms of directions, that the dual options can be taken by the employee, both together. Secondly, in terms of those employees who had already retired prior to 14 and who had not taken any option, for them they have said nothing can be done, we are sorry, but that is something which closes. Second category, those employees who had retired prior to 14 but had taken an option, they will continue with whatever the option they had taken. Their status quo maintains, nothing much has to be done. The third and fourth category were merged. So those employees who were serving and maybe who had taken the first option or not taken the first option, they were effectively merged, and that is where Article 142 exercise was taken, and they said both of these categories can now give their option within a period of 4 months, and from there they can take forward and take benefit of the system. So this is the first thing which has come in terms of taking of options. Today the situation is that within this 4 months period, these two categories of employees can go ahead and give their options, a dual option, and take the benefit. The problem probably is that in the meanwhile certain people have retired. They are no more serving. Now what would happen to those people who have in the meanwhile, during the pendency of these matters, retired and they have not given any option? Whether they will be permitted to give the dual option and take the benefit is something which probably has to be in some proceedings looked into. There seems to be a vacuum insofar as that portion is concerned. But this is the first portion of options to be taken. The second issue was about the additional contribution by the employee, 1.16. This was the first proviso to paragraph 11.6, where by the scheme they inserted that additional contribution has to be given by the employee. That has been struck down by the Supreme Court. It said that is something which is not permissible within the corners of the Act, and therefore we cannot permit. However, and probably if I may add a bit strangely, what they have done is they have, keeping probably in mind the requirement of the funds of the government, suspended this particular law which they have laid down. So first they hold it is ultra vires the Act. Now they have suspended that particular operation of this judgment for a period of 6 months, and they have granted liberty or maybe indicated to the government whether they want to amend the Act or they want to amend the scheme in a way that they are able to generate those funds from an alternative source. Till then the employees are supposed to continue contributing for the next 6 months. So this portion of the first proviso to paragraph 11.6, which otherwise has been held to be ultra vires, that has been suspended. So far as the third part is concerned, in terms of extension of the period, under Article 142, as I said, they have given the 4 months time where a dual option can be given by the employees who have been serving, and they can have the benefit of this particular scheme. Lastly, there was this issue about the exempted establishments. So under section 17, there is a provision where the government can exempt the establishments for the applicability of the Employees Provident Fund. 17(6) specifically provides that even if they are exempted for the Provident Fund, for the pension scheme they will still continue. Yet there was some confusion about the applicability and whether for the pension scheme the employees working in exempted establishments would be the benefit or not. The court has declared quite clearly that even the exempted establishments would be covered under the pension scheme, and therefore the employees of that as well would be benefited. So this really is the contours and the sum and substance of this judgment.
Thank you very much. Any questions? Thank you very much, Bharuka. So nicely, extempore, honestly, I mean, more than expectations. I mean, we're not confused. Just give a huge claps to her. Thank you.
Sir.
Yeah, please, sir, please come.
Sir, please.
No, it's okay.
No, to add this mic, sir, mic for you.
No, not mine. Is there any justification? No, they said the first option need not be exercised, it merges into the second option, you can do that. So that so far as those people who have not exercised the option, so far as those who are continuing, they said that option was not required. That is what R.C. Gupta also said. So that those people who retired prior to 14, what is the justification for saying that your option, which you are given to those who continue, just does not exist, just vanishes? I went through the judgment again and again. I find no reasons are given as to why it is given, except the 4 classifications are made. If the after making the classification, those who have not exercised the option are given a further time to give option, how is it that is denied to the others? Because that is what R.C. Gupta also said. You remember, R.C. Gupta's reasoning has been upheld.
Yes.
And then you also pointed out, that's occurred to me only now, that those who have retired and who are not here on the date of the judgment, what will happen to them? That is, those who continued after 14,
That's right,
but retired prior to the
judgment. Yes,
judgment,
sir.
what will happen? And that's also a very good point,
Yes,
which may require clarification. But I was wondering, how is it, by what process of reasoning is this being denied to those who have retired prior to 14, having held that no option need be exercised by them, and those who are continuing can be given a further option for a period of 4 months or 6 months, whatever it is. That I could not make out. What is the process of reasoning? But classification, yes, but both the classes will be the same. Because under the old 11.3, they did not have to exercise an option, and that's why you are giving option to those who are continuing. But for those who have stopped halfway, and they were all litigating, many of them, they were litigating all through.
Right.
They're saying that 11.3, there no need of a further option, you cannot have a cut-off date, I can commit at any time that I want. That is why R.C. Gupta said you can do it.
Yes.
Provided you deposit the money that you've taken back, you can do that. But then I was finding is there a fundamental flaw in the reasoning of the court when it said those retired pre-14 will not get a at that time finding it a little difficult to explain to the clients also how that comes.
Yes, sir.
Yeah. Now what is your time? Yes.
please.
This is just no question and answer.
Yes, absolutely. So just
Clarification for what, sir?
Yeah.
So you're actually, sir, you might be right, sir. The thing is, what I can understand is this: that even though they have retired at that point of time, so let me start with this. When you're looking at reasons, very frankly, sir, I think the directions at paragraph 46 seems to be somewhere, not really supported by the judgment in a lot of areas. So maybe
there are, but there is no good reasons to support.
there are no good reasons, and there could be reasons for no good reasons. But you are right, sir. Once, so suppose like this retired group who have retired between 2014 till the date of judgment, since there is a vacuum in the judgment. So even before that, the moment you're providing dual options to those who are continuing to serve, which means you are merging the first option with the second, which also means really that the first option is kind of inconsequential.
That's right. That's
Yes.
That's it. And I thought during discussions it was agreed that it was not necessary, 26(6) option having been exercised,
Yes.
and 13 not having such a proviso earlier, it was not necessary to exercise a proviso, and the Kerala High Court and all held that no artificial cut-off dates can be any time that they want. R.C. Gupta upheld it.
Correct, absolutely.
Having said that, how is it that we deny to them? See, and also one more thing is 15,000 is limited now.
Sure.
Now, who is that employee, that wonderful employee who is not getting 15,000 rupees a day amount today? And therefore, see, of course, you may say it trenches upon policy, but a perverse policy can also be interfered with, isn't it? For you to say that hereafter only people above 15,000, it's against all canons of welfare legislation, that is not that, as you rightly said, they said 15 is okay, amendment is okay. Very good. Strictly looking at the legislative competence to amend may not be lacking. But then can you take away the benefit of all these people who have been getting it all along, and then from today onwards, nobody will above 15 will have.
That's right.
So maybe it
Okay,
trenches
just
upon
take
policy
it.
also. I will agree with you. You can't find fault with the court for doing that because that's a policy. The court can always say we are not going after big money people. We can only provide for those who are below 15. It's only we are catering only to that section of the populace, that section of the workmen who are doing that. Therefore, maybe we cannot take objection to that. But then, as you rightly said, it was laboriously argued that limiting it to 15% would be perverse, it should not be accepted, and all that. And even that, you referred to it, hitherto it was last 2 months, 3 months salary to be taken as indicator of the future pension. Now it is at 5 years.
5 years.
See, 5 years, the world has changed. See, for within 5 years, one or two the pay commissions may have come, and therefore the value of money, everything has changed so much. You know, you take a big, and that was argued to be perverse. I did not find good reasons to reject the argument.
Not at all, sir.
It's not.
It's just small
Yes.
paragraphs, and it's actually sort of recording the contentions, and straight away, in my opinion,
It looked more like an executive order. Yes,
Yes.
you have a problem. Here
That's
is the solution.
right. This is the solution. Absolutely.
That's the way I read it.
you're right, sir.
Okay, well, I just good. I'm very happy with you. I thought it was a very complex subject, but the way you analyzed it, I really appreciate it. I'm very happy that you made it look simpler for even
Yeah,
one who was
please,
not
correct,
was
sir.
not there to hear the argument or was not party to the litigation. You made it look so simple and then analyzed it. We all have reservation. Every judgment we may have reservation within the judgment. They also try to do a very good job by giving some specific direction, so that future confusion is avoided. I don't agree. I mean, with great respect, I don't agree, because many of the directions, as you rightly pointed out, do not seem to be reasoned out properly. Right?
That's a big
That
problem.
is a. Thank you very much.
Thank you very much, Basant sir. Nice
Thank you so much, sir.
Yeah, I enjoyed your talk.
Thank you,
I
sir.
was held up in court one. I thought I'll not be able to come, but I rushed thinking
Very-
that
very
I have
grateful,
a
sir.
short gap. Therefore, thank you very much. I
Thank you
really
very much, sir. I mean, you
Thank you.
analyzed
Yes.
further the world also. Thank you very much.
I really enjoyed.
Sir also appeared in this matter. Bharuka
Yes.
also appeared in this matter. So
Yeah,
we are
we were all there.
Yes.
I'm not in a way criticizing the judgment, but it deserves to be discussed.
These two.
The inadequacy in the judgment deserves to be discussed. I mean, in fact, when we had this Friday group itself, we thought, I was a judge. My judgments are not discussed. I'm very happy. Because when people critically look at it, you realize where you have erred, and therefore that's the purpose. It's an academic discussion that we are having. So even if you have pointed out some inadequacy in the judgment, I don't think there's absolutely nothing. That's what we are supposed to do. We do it every day in court. We criticize judgments. This judgment can also be criticized. You are absolutely right. You have tackled the bull by the horn by saying directions do not appear to be followed up with good reasons. That's what I felt.
So that's the impression we get, sir. There was something, sir, I just got to know an hour back. So in Canada, of course, we have the same kind of employee pension scheme, but there is also a self-employed pension scheme over there. So like the way over here, employees and employer contribute to that scheme.
The policy
Yes,
is the
sir.
state's burden to look after you during your old age and sickness. Now, in order to implement that, you could always say everyone must contribute to the PPF scheme, and the PPF scheme which they have could, as in the case of the EPF scheme,
Yes.
later on be converted into pension payment
Pension
also.
payment.
It's quite possible.
Very
It's
interesting.
quite-
Yes.
A welfare state must look at those possibilities.
Yes, sir.
That can certainly be done. In many of the European countries, that pension is paid, the state looks after it.
Yes.
If the state here does not have the funds to do that, it's perfectly possible for them to ask us to contribute. And then ensure that you are
Yes,
looked
sir.
after.
Yes.
Good. That again is a wonderful possibility so far as the
Yes.
welfare state concept is concerned.
Any more questions? Any more questions? Please, we'll take your autograph here and any message next page.